Dynamo, we shall start, ma'am.
Able to hear my voice, Jenny?
Yes, ma'am, very clear.
A beautiful smile is the best universal welcome. It can make the day easily. A pleasant evening to the August gathering of this fourth day faculty development program on intellectual property rights, organized by the PG and Research Department of Botany and Marian Star Center of St. Mary's College Autonomous Thoothukudi, sponsored by Department of Biotechnology, Ministry of Science and Technology, Government of India, New Delhi. A day without prayer is a day without blessing. A life without prayer is a life without power. Let us invoke the blessings of the Lord Almighty through this prayer song.
When you've prayed every prayer that you know how to pray, just remember the Lord will hear, and the answer is on its way. Our God is able, He is mighty, He is faithful, and He never sleeps, He never slumbers, He never tires of hearing our prayer. When we are weak, He becomes stronger. So rest in His love and cast all of your cares on Him. Do you feel that the Lord has forgotten your need? Just remember that God is always working in ways you cannot see. That's right. Our God is able, He is mighty, He is faithful, and He never sleeps, He never slumbers, He never tires of hearing our prayer. When we are weak, He becomes stronger. So rest in His love and cast all of your cares on Him.
Participants, kindly turn on the camera for the group photo with the resource person.
Ma'am, I've taken, ma'am.
Okay, Jenny. It gives me immense pleasure to introduce and welcome our resource person, Dr. P.R.L. Raja Venkatesan, to this August gathering. Presently, he is working as an associate professor and head of the Department of VIT, School of Law, Chennai. He did Bachelor of Law from Government Law College, Tiruchirappalli, during the year 2003 to 2006, and Intellectual Property Rights and Environmental Law from School of Legal Studies, Cochin University of Science and Technology from the year 2006 to 2008. He was awarded PhD in the topic entitled A Study on Public Use of Private Rights with special reference to intellectual property rights in India in 2012 from the Department of Legal Studies, University of Madras, Chennai. He was teaching cum research fellow and senior research fellow of intellectual property rights in Department of Legal Studies, University of Madras. He has cleared both NET and SET. He started his career as a guest faculty of intellectual property right at Tamil Nadu, Dr. Ambedkar Law University, Chennai. Thereafter, he worked as an assistant professor at School of Law, Sastra University, Tanjore. His areas of expertise such as intellectual property rights, environmental law, criminal law, and Media Law. Currently, he is guiding 3 PhD candidates in BIT School of Law and external member of doctoral committee for PhD committees, PhD candidates in other institutions, and member of board of studies in Department of Legal Studies, University of Madras. He authored 9 books and published around 56 research papers and delivered a good number of lectures on intellectual property rights, criminal law, and environmental law, etc. In addition to this, he received 4 research awards from VIT University of Exemplary Commitment, Dedication, and Motivation towards Research Publication the year 2015 to 2018. He has participated and presented papers in more than 80 international and national journals and seminars. He organized 5 national conference seminars, 4 workshops, and 2 international
அந்த வரக்கூடிய குழந்தைங்களுக்கு என்னென்ன அரேஞ்ச்மெண்ட்ஸ் பண்ணணும் அப்படிங்கறது நீங்க சொல்லிட்டீங்கன்னா இப்ப அரேஞ்ச்மெண்ட்ஸ் டீம் வந்து டிஸ்கஸ் பண்ணிட்டு இருக்கோம். அவங்களுக்கு வந்து அதாவது அந்த எனக்கு NCSC-னுடைய டீம்ஸ் அனுப்பிட்டீங்கன்னா புக் வாட்ஸ்அப் பண்ணீங்க.
He has organized 5 national conference seminars and 4
team இருக்குங்களா? 5 team
Kalevani ma'am.
Best 2 to
Kalevani ma'am, kindly mute your.
So அதுல வந்து
He has organized 5 national conferences, seminars, 4 workshops, and 2 international conferences as coordinator and chief editors of 3 international journals such as European Journal of Biotechnology and Bioscience, International Journal of Law, and International Journal of Law and Social Sciences. He acted as a judge in 10 international and national moot court competitions. On behalf of PG and Research Department of Botany, I wholeheartedly welcome you, sir. It is my great privilege to welcome our Secretary, Reverend Sister Flora Mary, our beloved Principal, Reverend Dr. Sister A.S. Lucia Rose, Deputy Principal, Reverend Dr. Sister Kualde Teras, and Director of Self-Supporting Courses, Reverend Sister Josephine Jayarani, Controller of Examination, Dr. Punita Dharani, Deans and Heads of various departments. I am extremely happy to welcome our HOD, Dr. Glory. I cordially welcome Reverend Dr. Sister Oroki Genesius Alphonse, Overall Coordinator, Member Secretary, Deputy Stoskoleski. I welcome all the eminent professors. Once again, I welcome one and all. Now I invite Dr. P.R.L. Raja Venkatesan to deliver a lecture on copyright. Over to you, sir.
Thank you, ma'am. Thank you so much for your introduction, ma'am. Thank you so much. Respected administrative head of this institution, respected senior professors and the professors and the faculty members of the institution, also other institution, organizing team, also the other participants, those who are all participating in the faculty development program. Very good evening to one and all. The topic in which I am going to discuss about it, law of copyright. Law of copyright. Let me to share the slide. Ma'am, is it visible, ma'am?
Yes, sir, it is visible.
Yes, sir.
Okay, ma'am. Law of copyright, it's like a 6-month subject. 6 months we have to study about it in order to know about the basic of copyright as well as the the importance of the copyright and how we have to get a copyright. But for the faculty development program, which we have audience from all the perspective, because the legal perspective, science background, engineering background, and other background, even the people from those who are working in NGOs and others, like it's like a multitask. I'm really very happy that the opportunity has been given to me by the organizer as well as the management to share some of my views. Basically, I'm the science background. I'm having it actually. I did my botany as well as the zoology science background from 11th standard to till BSc. And the importance of the IP, basically, there is a nexus between the science as well as the IP. At science and IP, there are a lot of things to be done, but in which the copyright is one part of it. It's a one kind of IP. When we think about the copyright, the people may think something about what exactly the copyright is all about, because basic understanding about the copyright depends upon the persons in which field they are. Take an example: if the man who is not having a legal background, and their perspective of the copyright will differ. The person with the legal background, the perspective of the copyright will differ. But the person is having a both background, the perspective of the copyright is different, despite the fact that there is a definition of copyright under the Copyright Act 1957. When we read the term copyright, it's it's a combination of copy as well as the right. Before moving to what exactly the copyright, we should know about what is meant by right. As far as the right is concerned, when we speak, the day-to-day activities, we can say that I have a right. Even your friends can say that I have a right. Even third party also can say that I have a right. What exactly the right? Right is nothing but an interest, in respect of which is a duty, disrespect of which is a wrong. If someone says that I have a right, that we have to think that all right, he has a right according to law. Because without law, there is no right. When there is a right, on the other side, there is a duty. If I say that I have a right, my right has to be protected by another person. That means they should not exploit my rights. This is the general, it's not a legal definition, general, the understanding about what exactly the right is all about. Basically, the copyright is not a positive right. It is a negative right. That means others are prevented, third party are prevented not to exploit my copyright. Another one is copy. If it is like a copyright, is it mean that I have a right to copy? I have a right to copy all kind of works? Or if I copy something, can I have a right for that? Take an example, I have copied 100 books, or I have copied 100 pages and write a lot of books. Can I have a matter of right? Whether I can say that I have every right over the materials which I have copied it. Is it mean that right to copy? What is that? When you go to the definition part of the Copyright Act 1957, it says that in section 14 of the Copyright Act, the copyright means authorizing the another person to do, or he can do that, or she can do that, or you can authorize another person to do on your behalf. That is a legal definition. Generally, copyright is a right of an author, right of a creator, right of a person who has created a particular work. Take an example. I wrote a book. If I wrote a book, who has a right? I have a right to exploit my book. What I did a hard work. And I exploited. My book should not be exploited by another person. He can do so, but only with my permission. But when you read the book, or when you read some, the materials, or when you read some the books, it clearly says that all rights are reserved, or it is a copyrighted. What it means? Does it mean that others are prevented not to copy it? Or whether after creating a book or creating a work, should you get a copyright? To whom you have to approach the copyright? Or is it necessary that your work should be recognized by way of giving copyright? Copyright is nothing but a right of a author or creator. It is one kind of IP, but it gives the bundle of rights. Bundle of rights to whom? to an author or to a creator or to a person who has created a particular work. It's copyright is a tangible property, but copyright is a one kind of IP which has a strong, sound enforcement on it because of the technological development. The new, the sectors, the new kind of or new author of copyright has a different dimensions. We have a copyright system, but we had a long history in order to know about the systematic development of the copyright, starting from the Gutenberg era, how the work has been copied. But all those things should be done to whom? Take an example. A lot of books may be written. Copies, more than one copies, multiple copies. And if you go to the history before 1436, it was very difficult to copy the work. But what they did, they had a printing press. They had a printing press. This is what the first printing press looked like. Who had invented a printing press? Who? It is none other than the Gutenberg. He had invented the printing press in the year of 1436. And what he did, he did in a German. He took multiple copies. Once he succeeded in his invention, and whatever the information he had collected it, he had an opportunity to copy it in a different, more than one platform. And he did, more than one copies, and people used to, approach him that how it happened. So in those days, it was like a miracle. And then systematically, what happened? Booksellers and printers, they expanded their business. Why? Because once there was an opportunity to take multiple copies, then booksellers and printers, they came to the pictures. In the year of 1483, what happened actually to the copyright regime? England was a major player for what? For a printing business. For the people like England, they used to think everything in a trade aspect. They used to think everything in a trade aspect. They invested much amount, then they printed the books. There was a regulation between the booksellers and printers. Finally, what they did, they called as a stationers. What is the public purpose on it? And we'll discuss about it later, but the object is very simple. The object of the copyright law in those days, even as of now, to disseminate the knowledge from one generation to another generation, to pass the information from one person to another person. Knowledge should reach all the peoples. But despite the fact that there was a trade in those days, they always thought about the public interest over that. And there was the principles. Actually, who has to regulate? It is none other than the administrative head in those days. And there was a act called as Licensing Act. Because they enacted that legislation of 1662. In England, what happened was that they prohibited the other persons who was not licensed to do it. That means the sovereign state who had an authority to permit the particular people to print the book, prevent the person who didn't have a license not to print the book. Then there was a systematic development in the year of 1709. There was an act called the Statute of Botany. It was a famous legislation. Why? Because without regulation, it is very difficult to regulate the copyright. It is very difficult. We have to systemize it. There should be a transparency and accountability. Then what happened? Though the sovereign state recognized the person like a creator or author to exploit his work, but they reduced the term of protection from 21 years to 14 years. For an example, I am an author. I wrote a book. My status is very simple. I am an author. I have every right to exploit it. How long? But as of now, life plus 60 years for literary work, because the books will be considered as a literary work, and life plus 60 years, my work can be exploited. Lifetime, the sense till the end of my natural life. Once I died, my legal heirs my legal heirs, they have every right to exploit my work after my death only for 60 years. But in those days, only for 14 years. Only for 14 years. But there was an argument before that. Why not we fix it as a perpetual right? And why we have to fix the particular term and protection? And why we have to say that only the limited period of time only they have to use it? What is the purpose behind it? I will tell you one thing. Copyright is not an absolute right. Copyright is a subject to some conditions and limitations within which the author can exploit. That means at any point of time, the government can interfere. At any point of time, sovereign authority can take over the right, provided if there is any reason which is listed as per the statute book, irrespective of the country. Because the systems all over the world, one or same, except a few provisions. But they always used to travel in a public purpose aspect. And if some property, if you give the right that it can be exploited in the perpetual right without any fixing any limitation, then that is also dangerous. Even for monopoly, there should be some, that some terms and conditions. Unlimited period of time, what the authority thought, it is not good. But even lifeless 60 years, then which normally what the government will do, if it is something like a useful work, they used to take over the work and they give the royalty to the author. These are all the the provisions we will discuss later on about it. And one more thing, as far as the copyright is concerned, on the one side we have to think it in a public purposes, on the other side we have to think about it in individual purposes. That means the trade, the people who are all investing huge amount in the printing industry and the booksellers in those days which we are talking about. And there was a level playing field between those two people, and they have to make sure that at any point of time creativity and all never ever go down. There should be a creativity. Always they used to maintain a standard of creativity. Take an example. When we talk about the corporate system in UK and USA, they had a strong corporate system. What about India? Whether we had a system in India or whether we have enacted a legislation in India, not before 1957, but I'm talking about the 15th century and 16th century. We were under the control of British people. We were all aware of it. Whatever the legislation in the 19th century and afterwards was enacted, it was under the dominant positions of the UK people. Because what happened? They used to say that this is the copyright legislation. Then we adopted as it is, without having much changes on it. And why? Because the act which was enacted for the Britishers, and that might be applicable in the place where they are, the situation where they are. But when we enact a copyright legislation to the country like in India, at least we have to think about the ground reality and proceed further. But that was not done in those days. And one more thing had happened when we talk about the copyright law. It's developed only systematically. Take an example in 1911, we had a copyright system, and it was applicable to British colonies, including India. And then there was a systematic amendment. And then in the year of 1957, we had enacted a full-fledged legislation in a copyright law. Then there was an amendment afterwards in the copyright law, there of 1983, 84, 92, 94, 99, in 2002, 2013, even 2021 also we had some discussion about it. Then another question will arise, when we had a lot of regulations, amendment time and again, do we feel that we have a copyright system, the strong copyright system? Can you say that our work is not copied, our work is not exploited, our work is not exploited by others without our permission? Take an example. As far as the copyright law is concerned, on the one side an author, on the other side is a owner. Author will be considered as a owner, but owner may be considered as an author or may not be considered as an author. what it means. I have decided to write a book. Then I wrote it. Afterwards, due to some economic capacity and all, I don't want to publish the book. I called upon some of the publishers. I had a negotiation with them. What happened that one of the publishers, they came forward by saying that, yes, I will publish your work. Then he did it. There was an agreement between me as well as the publisher. And there was a terms and conditions. There was a terms and condition that, royalty should be given like this, or you have to exploit the work like this. I will be considered as an author, he will be considered as a owner. Now the question is about, in case of exploitation, which one will prevail? Which one will prevail? I will give another illustration. I have been invited by the reputed persons, and I will be invited to deliver a lecture. Then I did the same through virtual platform. If I did the same through virtual platform, if somebody recorded it and they did exploit it for commercial purposes, another question will arise as an academician. Do I have a right to find a case against them for commercially exploiting my lecture? What is my role? My role is very limited. But I have been invited. I am delivering lectures, or I delivered a lecture. Once they recorded it and took a multiple copies, and they distributed to someone else by saying that it's a brief about the copyright law. What should I do? Do I have any right? Or if you deliver lectures, if your lectures is recorded, and if it is commercially exploited, do you have any right as an academician or other legal fraternity or other the people, those who are in a teaching profession and other professions, if they deliver lectures, what is the status? What law says? The first question is, what exactly the contract is? Next question is, what exactly the assignment is? Third one is, in what capacity you are delivering lecture? Fourth one is, are you in a contract of service or contract for service? But your service should not be exploited in a free of cost. It can be exploited in a free of cost, but there should be a reason behind it. There should be a larger public interest behind it. Another question you may ask, sir, when we discuss about exploitation, you are saying that a contract. What exactly the contract? We have a legislation actually, Contract Act 1872. Contract is nothing but an agreement enforceable by law. Contract is an agreement enforceable by law. That means if you say that you have entered into contract with another person, that contract should have some legal sanction. That contract should have been recognized, or there should be legal sanction by the legislation. Another one is agreement. Is there any agreement between me and another person who had invited me to deliver lectures? Can I say that my copyright has been violated by another person? Even recording a lectures and selling it for commercial purposes? What exactly the agreement is all about? Agreement, in the legal terminology, every promise and every set of promise forming for consideration of each other is called an agreement. Every promise and every set of promise forming for consideration of each other is called an agreement. What kind of promise? Somebody will invite, and we have to happily accept it. Why? Because we have to share our knowledge with others. They will share their knowledge with us. The terms and conditions. Another question will arise. Is it in a contract of service or contract for service? Take an example. I have been invited by the people, or you have been invited by the people to deliver lectures in the classroom for 1 hour or 1.5 hours or 2 hours. It depends upon the interest of the the student, or depends upon the time. You delivered a lecture. It was recorded by the student as well as the person who organized it. If they use it for academic purposes, that should not be considered an offense, because that is permitted as a fair use. That is permitted as a fair use. Why? Because they use it for academic purposes. We have a legislation like a Copyright Act, section 52 of the Copyright Act, which says that limitation and exception. That means which one would not be considered as an infringement, which act is not considered as an offense, even if they exploit your work. If it is for commercial purposes, that then he has every right to ask the questions. But if the student in a largest interest, or many student, if they exploit your work for an academic purpose, you have to be very happy about it. Why? Because they, at least one way or others, your materials will be helpful or your lectures will be helpful. Otherwise, it is not. What exactly the contract of service and the contract for service? As far as the contract of service is concerned, you are under the control of the particular person. Take an example, you are a full-time employee. As a full-time employee, you are working somewhere else. During the course of employment, if you create some works, or if you come up with a budget, you write the creative works. Who is having a right? Who is having a right? You are a full-time employee. You have been paid by the employer. During the course of employment, note this point, during the course of employment, if you have created something for which, you can't claim some individually as you have all the rights. Not only for corporate, I'm telling about the patent, other things also we have in legislations. And if it is not during the course of employment, or if it is not the part of the employment, and if you created some works for which you have every right, even during the course of employment, if you did it, author status will never ever change. Author status will never ever change. But this is nothing but a contract of service. What exactly the contract for service? As far as the contract for service, you have been invited to deliver a lecture, or you have been invited to prepare a set of question papers. To prepare a set of question papers, you prepared a question paper, handed over to the institution, not in your institution where you are working, even from some other institution also they will call you to prepare a question paper, to set a question papers. But after 2 years, you came to know that your question paper had been copied by some other institution other than the institution to whom you had a contract. Do you have a right to file a case against the particular institution by saying that, my question paper had been copied as it is copied without any obligation of mine? Do you have a right to file a case? What law says actually? There should be an agreement between the institution as well as the faculty. Whenever the faculty receive the syllabus, they always receive along with the rules and regulations. Who will have a copyright over the question papers? And the terms and conditions will be clear. How much honorarium they are going to give, what kind of amount they are going to give, what is the type of question paper you have to take, how the model they used to do. If that is a case, it is not a contract of service. It is none other than the contract for service. That means you are not under the control of the person who approached you. You are an independent. And it may be for setting the question paper. It may be for delivering the lectures. But they will give you the topic. But it is up to you to decide which one should take first, which one should take next. But finally, whether it is a copyright violations or not. If it is for commercial purpose, it is violation. If it is not, if it is for, doctrine of fair use, that means if they use it for academic purposes at all, it should not be considered as an infringement. The one more example I will tell you, the best example. As far as the copyright law is concerned, nowadays, due to the technological development, most of the people, they used to take the multiple copies. There is a problem. Even the University Grant Commission, time and again, they used to give a circular, they used to give a notification by saying that plagiarism itself is not permitted. Even self-plagiarism also is one kind of not healthy discussion. For an example, I have decided to write an article. I wrote it. I can give either endnotes or references, or I can give the footnotes. It depends upon the field you are. If you are in engineering field, one format will be formatted. Format will be followed. Science background will formatted. One format will be followed. Law background, one or two format will be followed. But the main point is that once you take the materials, you have to acknowledge it. Sometimes you copied 3 to 4 pages from the particular. Is it necessary that you have to acknowledge it? Take an example, sometimes you didn't acknowledge it. You wrote an article for 20 pages. You went to the library. You collected a lot of information, either as a research scholar or as an academician. It belongs to whom? Do you have a copyright over your article? Sometimes, if you, one more example I will tell you. If you are going to submit a paper to the conference or to the seminar, you used to send an abstract, afterwards you used to send a full paper, then the organizer used to send a copyright form. Do you have a right to say that, I would like to retain my copyright? Or whether they have a right to say that all the copyright belongs to us? Or they can go for another condition by saying that it is not copied, or what kind of conditions will be valid? Because they used to give some declaration form, or the copyright form used to say that you have to make sure that, it is not at all copied. Sometimes there is a rule, even there is a rule in UGC that, 10% of plagiarism is permission. In some places, they are permitting for 15% of plagiarism. What kind of originality the copyright law expect? Originality means whether the copyright law expect 100% originality. Is it necessary that 100% originality is possible? It is mandatory. Is it really possible that you can show that I have a work which is 100% original? Is it highly possible? Or it is impossible to read? Or if that is the case, what is the the purpose of adding something as a references or footnotes or endnotes? Even the people used to some acknowledgement by saying that somebody helped by giving the references. But law is very clear that it should not be copied. But if you take some, works from other, some works from, or some pages from other, some pages from other, works, you have to acknowledge them. You have to mention them. Sometimes you can say that in which page, which edition you just, from where you copied or from where you added. I will tell you one thing. Copying also is not easy. The people can think that, the work is copied one. Work is copied one. 20% copied, 30% copied. Even if you want to copy the work, for which you have to read a lot of books. Otherwise, there will not be any correlations between the first pages to second pages. You have to read. When we read the old cases, there are so many cases are there with regard to the copyright law. There are issues that arise. Take an example, I will tell you. There is a doctrine called idea expression dichotomy. Idea. Whether idea can be copyrighted or not. Take an example, one of you has excellent idea that you will write a book, or you will address the gathering, or you will deliver lectures. Whether your idea will be protected as per the Copyright Act, what Indian law says, I have an excellent idea. Idea per se is not copyrighted. Idea per se is not copyrighted. But that idea must be expressed in any tangible form. It should be expressed in any tangible form. Idea per se is not copyrightable. Why? Because it is not visible. If idea is converted into any tangible form, then those form of expression can be copyrighted. There are cases, but I don't want to go in depth in the legal perspective. Why? Because audience from all the areas, and we are handling the classes to the legal facility is different, because we used to tell a lot of cases section. Here I used to limit it. Why? Because I was giving more about the more clarity on the basic concept about copyright. There was a case, Anil Gupta versus Kunal Das Gupta. Actually, I will tell the concept. In this case, what happened? one person who had an excellent idea. He had decided to create a program called Suyambaram. That means the idea is very simple. In case both male and female, if they are going to get a life partner, what they will do that they will go for the events like bride and bridegroom, bride family and bridegroom family, and they will meet in one place and they will facilitate it to understand each other families. And he explained about this concept to his friend. Then he started the program called Swayam Viva. Now the question is about that infringement of copyright, because I expressed my idea, and who implemented the idea first is also questionable. I expressed it. It's like telling the story. It is like telling the program. And who created it first or who implemented it first, sometimes there is a copyright issue. But unless and until if you put it in a form of expression, your work should not be protected. You can say so many things, or you can have a lot of idea, but that has to be protected only because if there is any tangible form. Take an example, the best example. The people can say that I have decided to write a book, I have decided to produce a movie. But they used to say 1 year, 2 years, 3 years, they used to say continuously. But another person did it. Who will get a copyright? That person will get a copyright. Why? Because he is the first to the market. He's the first to the market. He has every right to get the copyright. And one more thing I will tell you, that with regard to the lecture, delivering a lecture under the copyright law also is permissible. Because if I deliver a lecture, you deliver a lecture, you will be considered a performer. Your act is nothing but a performance. As per section 2, subclass Q, the lecture method will be considered a performance. You will be considered a performer. Because a person who delivers a lectures should be considered a performer. We have every right in a lectures in which you are a part of it. And there are other ones, in addition to lecture, will be considered a performer. This is the one. This is nothing but that acrobat. Now the question is, in order to perform this work, is it necessary that the person should have some extraordinary skill? This one, acrobat, juggler, and even this one, the concentration. This is another one. Whether all these works will be considered as a the skill-based one, contour. This one. The last one is snake charmer. What kind of skill we need in order to perform this work? But as per the copyright law, the snake charmer will be considered as a performer. Actually, the skill is nothing but a powerful. You can change the entire system, entire world by using the skill. The information is that kind of strong and powerful, where the copyright law plays a major role. Because information that much powerful. Why? Because irrespective of the field you are, irrespective of the profession you are, if you create something new, but you have a right. But the only thing is that you should know how to exploit those rights. It may be for teaching, maybe for the cine field. It's almost all the fields where the copyright law attract. There is another one. These are all the amendment actually, as far as the copyright law is concerned. There is another one. Let me to explain about it. There are a lot of slides, but for time concerns, I just tell only the important areas. Another one is, what are the works can be considered as a protectable subject matter under the Copyright Act? What are all the works? We can call it a subject matter of copyright. There are so many kinds of work can be considered as a subject matter of copyright. First one is literary work. Second one is dramatic work. Third one is musical work. Fourth one is artistic work. Fifth one is sound recording. Last one is cinematograph films. What exactly the literary work? Section 2, subclass O of the Copyright Act speaks about literary work. What exactly the literary work? Literary work, it include computer program, table, compilation, and databases. You must ask the question, sir, what exactly the computer program? Why we have to discuss about those computer program in the corporate law? Because science background, on the other side, engineering background, third side, computer science background. If you are a science background, the patent law will play. If you are a computer program background, both patent as well as the copyright law will play. But there should be a definition for computer as well as the computer program. Even there is a provision in the Copyright Act, Section 2, sub B, which says what exactly the computer. What is mean by computer program? Computer is nothing but a set of, it is like information processing capabilities. On the other side is a computer program. It is nothing but a set of instruction expressed in a word, code, scheme, or the another code. But to perform a particular task and also to achieve a particular result. You note this point again, to perform a particular task and also to achieve the particular result. Section 2 FFC of the Copyright Act, which speaks about what exactly the computer program. But the object is very simple. Irrespective of the work should be protected, and you have to prove that you are a person or a first person to create a work. Then there is elaborate provisions is there under the section 22. And once you have a literary work, books and all will be considered literary works. You have every right. You have every right. Not only a single person. Take an example, I will tell you. More than one person wrote a book. First person will be considered as an author. Second person will be considered as a co-author. Now, question arises: if a first person died, whether copyright right is gone, or will it go to the second person? And life plus 60 years will be counted where? If it is more than one, even if the first person died, right is always there. And the right should be recognized by the copyright. That is another point. But you can't say that I have a right, I have a right. You should ask the question whether you have a right has been protected under the Copyright Act or not. That is also another question. But one more thing you have to know that, the best method is if you write a book, it's not a two persons, more than two. For example, sometimes writing an article, writing a book, 4 persons, 5 persons. But it is a rare combination actually. Sometimes 1 or 2, generally 1. Exception cases also 3 and 4. But there is another issue. I think many of you are aware of it. Even the protection of copyright also have some different standard. And the protection of copyright will never ever vary based on the standard of work, but we have to make sure that it is not copied. It's very simple. Take an example. One publisher, they have one standard. Another publisher have another standard. But both are having some, same uniformity only to make sure that whether work is copied or not. But the standard may differ from one person to another person. But that is not, that and all will be considered, depends upon the person. Even the talent and caliber and all will be considered. But what law says, if it is not copied, then the person has no right to file a case against others. And you are all well aware of the provisions like, how should get a copyright and how should, whom we have to approach, I will explain later on. But there is a process is there. For general, the people used to get ISS number. I think many of you are aware of it by way of applying it. And international standard serial number. For the books, international standard book number. But just because you are going to get a right or going to get a registration, it doesn't mean that you have a 100% guarantee. But registration of copyright is only optional. It is not mandatory. It is not mandatory, it is only optional. But even if it is optional, and once you came to know that your work is copied by another person, you have a right. Even if it is optional, you can go to the court, file a case, make sure that your right is protected. And there is a debatable issue as far as the copyright law is concerned. Whether author had rewarded for the work which they did it. In Tamil, they used to say that எழுத்தாளர்களை கவனிப்பதில்லை, படிப்பவர்கள் எப்போதும் ஏழைகளாகவே இருக்கிறார்கள். Intellectual or not responded. Sorry, intellectual or not recognized. படித்தவர்களை, திறமையானவர்களை அங்கீகரிப்பதில்லை. There was a debate actually. Whether, the sense that only in exceptional cases I'm talking, not always. whether the work of an intellectual had been protected it or not. I'm telling about in a copyright aspect, in an academic perspective, which I'm talking. Whether the work of an intellectual had been protected, whether intellectual had enjoyed the fruits of the labor. But actually, when we read some cases, it is not. The best example is Bharatiyar. He wrote a lot of, the poetry. He wrote a book, and he was an extraordinary person. But there was a debate as far as, the Bharatiyar work is concerned in Tamil Nadu. And what happened? There was a long history whether the Bharatiyar work should be nationalized or not, whether the government should take an initiative in order to, acquire the rights of the legal heirs of the Bharatiyar and to nationalize the work. And, the people should know about the contribution of the Bharati. And what happened? There was a debate in a legislative assembly. You take it as an academic aspect. There was a debate in a legislative assembly also that Jiva is Jivananda. He spoke. He had a discussion in a legislative assembly. And he used to say that the Bharatiyar work, should be recognized. It should reach the nook and corner of the people. The people should know about it. What is the contribution of the Bharati? And they should know about it. And he wrote a lot about it, including the importance of the freedom and the rights of the women. He had touched almost all the aspects. And at the time, what happened? Bharatiyar family, they were in poor conditions, the pathetic situation. His wife had no other option other than to approach someone else. Please, my husband didn't acquire any property, but his property is only the books and poets and all. And then some of the rights had been assigned to some persons, including the AVP Chichar. And later on, all the rights had been acquired. Even he also himself said that I acquired the right of the Bharati, but the government wants. We are happily given. And finally, the government took, the entire the rights. And why I'm saying this, the value of the copyright was realized in those days in the public purposes. But it has been, deviated in certain extent in a recent context that, without, subscription, nothing is free. Even some of the standard journals, even some of the ones, they put a lot of conditions. And the purpose of the copyright is different, but the reality is different. But they cite the reason by saying that we had employed so many people that you have to manage, but in order to give the good and standard work, at least we have to fix some rate behind it. But whether the work is a standard or not, it depends upon the persons actually. Whether it is standard or not depends upon the person. But the copyright is nothing but a standard, the property right. It is not a mere right. It is a property right. But I have a right. For example, I wrote a book, nobody should touch upon it. Nobody should copy it. Nobody should copy the sense for commercial exploitation. But there are so many exploitations going on, even in the technological field, we don't know whether almost the 20 pages, how many pages copied. And even there are technology by saying that even the plagiarism and other checks, sometimes there is a technique that in order to avoid and limit the plagiarism report and all, there are so many techniques for that. But work should be recognized. Why? Because at least you try to do it. You try to do it. Compilation. There is another issue with regard to the compilation. Take an example, collecting the material or getting the works from somewhere else. And the people used to say that you compile the work. For compilation, copyright is there. Yes, for compilation also is there. But in those days, what happened was that one person, he collected the phone numbers and he created the telephonic directory. He collected the phone number, brought it as a book. Would it be considered as a copyrighted material? Yes, it is a copyrighted one. Why? Because he collected information. Collection of information itself is an art. Once he collected information, printed it as either as a book or others, that it should be recognized. It should be recognized. There is another case. In this case, what happened? Tante Periyar. This is another case. There was a debate, and all of you well aware of it. The contribution of Tante Periyar. And what happened was that there was a case, Periyar self-respect propaganda institution versus Periyar Dravida Kazhagam. There was a case in a corporate perspective. He was a great leader and he used to speak about the rights of the women. There are so many things he spoke, but there are few things which was very much important in order to maintain the equality and maybe, some may be contrary, but some also will, will be useful to the people who always strongly support about the social justice and others. But he wrote a lot of things about the women. And he wrote a lot of things about how the people should always be expressed. But he used to deliver a lot of lectures. He used to address the gathering. And what happened was that so many the speeches brought it as a book. In the year of 1925, he had started a journal called Couriers. Nothing but a people rule. Then there is another French revolution, Pagutarivu, rationalism. In those days, it was printed only in a cheaper rate and inexpensive paper. The object was very simple, that knowledge must be disseminated to others. And in this case, the Periyar Self-Respect Propaganda Institution filed a case against the Periyar Travida Kadagam by saying that, the rights of the plaintiff was infringed by another person. And there was a debate whether Periyar had assigned any rights. The Periyar had assigned any right to anybody else, including the organization who filed the case. And they argued that he addressed the gathering, we collected an information, and we took a note of it. Finally, he brought it as a book. Another argument was that in the absence of an agreement between the author who wrote a book, or in the absence of the legal heirs, there are so many arguments was there. But finally, what the court held, that more knowledge must be disseminated. There was no infringement in it. And even the person who addressed the gathering, another person will take the note and finally he go to his house and sit and write and bring it as a 10 pages or 20 pages, publish it the next day. It would not be considered an infringement. Why? Because he gathered an information without the skill. It's very difficult to gather the information. Systematically, he has to he has to publish it. He has to gather it, collect it, and publish it. And there is a provision, section 52, subclass 1M, reproduction of it in a newspaper and a magazine. Actually, as far as the copyright law is concerned, section 52 is very, very important. Why? Because it always, speaks more about public interest rather than private interest. The one example I will tell you, in our legal field, judgment. People can say the Tamil, Thirpugal. It belongs to whom? Thirpugal yarukku sondam. It belongs to whom? Can you copy the judgment? Can I copy the judgment? For example, once a judge delivered a judgment, would it be considered as a public document? Or if sometime, if I copy the work, or if I copied 20 pages of the judgment, whether the judge has a right to file a case against me, or would it be considered a government work? It's nothing but a government. But for the public purposes, what is happening once judgment is delivered? It is in a public domain. It's a public document. It is a public document that you can copy it, even you can have a discussion on it. You can have a discussion on it for the larger public interest. It is there, under the section 52 of the Copyright Act. Another example I will tell you. Sometimes the reproduction of the newspaper items, but they used to give an acknowledgement. They used to give an acknowledgement by saying that so and so views or copied from so and so, or so views from extracted from the so and so pages. And these and all, why we have given this much exception not to consider as an infringement. The knowledge should be shared. Otherwise, it's very difficult. Otherwise, the knowledge will be like the Copyright Act should not be a stumbling block, and it should be helpful to others. There are cases like University of London, for instance, University of already told you that work must not be copied from another work, but it should originate from the author. It should originate from the author. Sometimes what will happen, if you read one book, read another book, the people can easily guess that, more than 70% had been copied from the previous book. Would it be considered an infringement? Would it be considered an infringement or not? The previous book. And unless and until if it is acknowledged or if there is any reference, not 70 pages, If it is 1 or 2 pages, at least you can justify it. And I have given a reference. If it is entirely copied, that means a substantial part of the book is copied. It is nothing but infringement of copyright. It is nothing but a violation of copyright of another person. There is another issue with regard to the dissertation and the thesis. Many of us, are well aware of it. As far as the thesis is concerned, you are guiding a student, like you are guiding a PhD scholar. As an academician, you know that the role of an academician in order to mold your research scholars. He joined under our guidance before 3 years back or 4 years back. He submitted finally the thesis. Now it belongs to whom? Whether it belongs to university, or it belongs to the person who submitted, or it belongs to both, author as well, the guide as well as the research scholar. What kind of contributions? What copyright law says? And if the research scholar says that, the work for which I am an author, whether university can file dispute, or whether the author, the research guide can say that I am also author, I will be considered as a co-author, you will be considered as an author. But research thesis, as well as the dissertation, it is prepared by the student. There are few cases where, that it is the work of the, scholars, and we can guide them. Writing a separate article is different. But if you guide them if you tell them that the thing has to be done it, finally, if they followed it, brought it as a thesis, they are the one that they have advised. And there are some cases where they used to say that translation work also will be considered as a literary work. What does mean that? You wrote a book in Tamil or Hindi or Malayalam, Kannada, and other languages. One of your friend approached you over the phone that I would like to translate your work from Tamil or English or Hindi to some other languages. But what you said, Joel, that if you want to do it, you do it, but it should not replica of the book. But what your friend did, he translated your book in their versions. He published it. After some time, you came to know that your work has been published, translated in other languages, more than 1 languages and 2 languages. Now, my question is, would it be considered as an infringement or not? What court heard? But you created a work first. You have every right. If other want to translate it a different, that the languages, they have to get a permission from you. And if they did so without consent of you, and it would amount to infringement. And if you want to be in a safer side, if you want to translate the work, that it is better that you have to get a permission. Otherwise, it would be considered as a copyright. This is a quite interesting case. In this case, what happened is the Indian Income Tax Act. Actually, both of them wrote a books. But what, the plaintiff argued that my book was copied by the defendant. For example, A and B. A filed a case against B by saying that my book is copied by B. B submitted a counter statement by saying that this fellow also copied the book from law and practice of income tax. That means both of them copied it, and they took the sources from the same material, same books, some other books, and the sources are one or same because the Indian income tax manual is there. Both of them collected information, gathered some point from income tax manual. That is the question of infringement. He can say that it was copied. This fellow says that I only did copy, but he also copied. Both of them copied from some other that it would not be considered as an infringement. In a literary work, it's a vast area, but for the time being, we're going to confine with a few illustrations. Then another one is a dramatic work. As far as the dramatic work is concerned, who will be, considered as an author? In case of drama, the person who perform it. There are work, take an example, entertainment in a dump show, and also cinematography. This is the work, choreographic. Everything will be, protected under the copyright system. This is a systematic process, actually. This is also entertainment dump show. It can be protected under the copyright law. Third one is musical work. Whether musical work should be protected under the copyright? Yes. Who will be considered as the author of the musical work? Composer will be considered as the author of the musical work, irrespective of the notation of such work. Actually, the music is a powerful medium. It's a powerful medium where excellently they can compose it, and once they composed it for the musical work, composer will be considered as an author. Composer will be considered as an author, and whether he performed it or not, that will be decided based on the case by case basis. But once he has been approached by another person to compose it, and he composed the music, then he will be considered as the author of the work. Another one is artistic work. As far as the artistic work is concerned, take an example: painting will be considered as artistic work, sculptures will be considered as artistic work, architectures will be considered as artistic work, diagram, chart, plan, everything will be considered as an artistic work. Just to see that the copyright law will always protect this kind of creativity, and it involves the skills. It involves the skills, and it's not easy to paint. And this image, just to see that it's a painting, and we have to recognize it. We have to recognize the author. We have to encourage the author. We have to always support the author, and we have to encourage him and to boost him by saying that, okay, this kind of work which you did it, and once we encourage the author, and it will lead to dissemination of work and the creation of work by another, also more work he can create it. That is what the copyright law always expects. These are all the works. It will be considered as an artistic work. Another one is cinematograph films. Actually, as far as the cinema industry is concerned, you can read a lot of cases about the copyright law. Lot of cases. So one person will file a case for seeking injunction. Another person can say that the movie should not be screened. Third person says that amount is not paid, therefore he should not screen the movie. What exactly the cinematograph films is all about? It is nothing but a moving images. And in those days, what happened? He was a Tamil superstar, this way, Tyagaraja Bhagavathar. And in those days, what happened as far as the cine industry is concerned? The actor had a limited role. Actor had a limited role. But as of now, it has totally changed. But in those days, what happened? There was one case. Devanand versus Deluxe Films Limited. Devanand, as in the actor. And he filed a case against the producer by saying that amount is not settled. That means the balance amount should be settled. Otherwise, the screen should not be, the movie should not be screened. And as per copyright law, producer will be considered as an author of the cinematography. Producer. But whether the actor can file a case, whether actors can file a case. But in that case, in those days, what happened? Actor didn't success. Why? Because law didn't permit the actor to file a case. But in case if there is any agreement, they can do it independently. But now the trend has totally changed. But even in cinematograph films, there is an agreement between the producer as well as the actor, the actress. There is an agreement between the musician. There is an agreement between the producers as well as the person who composed the music. But there are so many people actually. They have some separate agreement. Lyricists, the people who used to write a song. And there is a separate agreement between them. And the rights of these people should be recognized, and it is there. And there are cases which I read it, that, in case of an infringement, they have every remedy. As per the Copyright Act, they can go to the court and file issue. And the one thing is that if it is copied, that is different. Sometimes I think you are well aware of it. There are movies against which the people used to file a case that movie should not be screened. Why? Because story was copied. Tamil used to say that என்னுடைய கதையை திருடி வித்துட்டாங்க. Because the story has been copied. There are movies I can say that there was a case like even in the Ramana, even the Sarkar. There are few movies after Ramana I'm telling. But the Sarkar, there was a controversial issue. But finally they had no other option that finally acknowledged the person who wrote a story. The acknowledgement. Sometimes, whether it is copied or not, it depends upon the substantial copy of it. Whether which part they have copied it. Sometimes, if it's the title and story, they used to register it. They used to register it. This is another mechanism called sound recording. Whether the sound recording can be protected or not, yes, sound recording also can be protected, irrespective of the medium in which they did it, it has to be protected. This is another one is lyricist. You should know about the contribution of the lyricist. In Tamil, we used to say that Padalaasiriyargal, but their contribution is, always appreciable one. Take an example, Kannadas. Take an example, Pattukottai Kalyanasundram. Take an example, Vali, Muthukumar. There are so many people. I'm telling only in a few states. But if you put the entire India and also you compare with the people from the entire world, lyricist performance is very much important in the movie. And now the question is whether they paid it. That is one aspect. Whether their work is recognized or not in another aspect. Third one is whether they had expressed their work in a commercial exploitation or not. The best example, that all of you well aware of what happened to the lyricist Muthukumar. And whether the actors and also the lyricist and the composer, who is having, more, economically strong and sound. But as far as the lyricist is concerned, only few. Rest of them is not. Rest of them is not. And there is another controversy. All of you, I think, might be read it in the newspapers, and there was a controversial issues, and there was a case between musician Ilayaraja sir as well as the singer Balasubramanian sir, and finally it was settled. But there was an issue by saying that Ilayaraja sir said that you should not sing my song, and since I am a composer, that I have every right. Then though both of them are a good and close friend in a legal perspective, and finally they settled, and the law is very clear that if it is a musical work, a musician has every right. But he has every right to file a case. And the only one thing is that as far as the commercial exploitation aspect, you have to look into that. Even in that case, what happened? Somebody who sings the song in a roadside, can you file the case against him? And in the name of orchestra, what you will do if sing the song? If it is a commercial item, whether you have to list the name of all the songs and go to the authority by saying that these are the song I'm going to sing, and this much amount I will give. Certain implementation aspect also is very difficult. As I told you already, who will be considered as an author of the copyright work? And as per section 17, there is a section is there. Author will be considered as a first owner of copyright. For example, I wrote a book. I am a first owner of copyright. I am an author. I am a owner. First, my status is an author. Next, my status will be considered as a owner. And another one is, in case of an author and owner, there are some issues. Take an example. There is a right called moral right. That moral right can be claimed by an author at any point of time. The best example I will tell you. You wrote a book. One of your friend included his name as an author. Your name is removed. What will you do? Because you worked hard. Now, what will you do? Can you file a case against him? Another issue. You wrote a book. You approach the publisher. You give all the 100 pages or 150 pages by saying that please, you should not remove any pages, all the pages, you just print it and you bring it as a book. He distorted some pages or mutilated some pages or modified some pages. But there is an agreement between you and him. What will you do? But as per law, it is very clear that moral right can be claimed even after the economic rights are assigned. Just because there is a contract between you and him, it doesn't mean that you don't have any right. You have every right to say that my reputation is gone because of your activities. Because at any point of time, there is a value for personality, reputation. Corporate law always, recognize those rights. But each and every people, they have a personality. But each and every people, they have, the reputation. It depends upon the field they are. The people, they have a confidence. The people, they have a respect. To take an example, if you want to watch the movie, people will ask who is a director, who is an actor. And if you want to read the book, the people will ask who wrote the book. If you want to listen to the lecture, the people normally ask who is going to deliver a lecture. Why? Because the people has a confidence with the person who delivers the lecture that it will be really good, standard and useful. And each and every people who create a particular work, has some standard. That standard either should not be diluted, that standard should not be distorted or mutilated by someone else. They won't tolerate this. They can file a case by saying that how it happened. And there are cases I can say that no, in few cases, I don't have time, otherwise can I explain it? In few cases, what happened, they used to, approach the people that this is the book, this is the novel, you can bring it as a book, you can produce it as a movie. What normally producer did, they entered into agreement. And he agreed that your novel will be, bring it as a movie in a different form. That's a form is different. One form is a book, another form of expression is a movie. And he produced the movie, but whatever was there in the novel, more than 30% was not there. For an example, introduction is not there, conclusion is not there. That means the climax is missing. But whether the author has a right to file a case against the producer, he has a right. He has a right. But he can, he can file a suit by saying that based on the agreement, you have to follow it. You have to follow it in letter and spirit. But there are cases I can say, these are the famous cases. Amarnath Sahil, there was one case in which what happened, the sculpturist, he had invited by the government in order to create this bronze mural. Later on, government itself removed those murals. And then we went to the court to file a case by saying that how it happened. I need that bronze mural and also compensation. Court gave it. Why? Because even in case of installation of the statue, and this sculptor has every right, because he was a sculpturist. Tamil used to say that Sirpi and the Salai because the sculpturist has every right to file a suit against the persons who damaged it. Even irrespective of the government, he said that I need compensation. I need compensation. They gave it. This is another case. Naga Beshi, she was a singer. Actually, she had been approached by the producers that you have to sing the song. Later on, what happened to the technology development? They muted her voice. Then she went to the court and filed a case. That the court said that no, it is nothing but violation of moral rights. As I told you already, the author can enter into assignment as well as the license. He has every right. And in case of assignment and license, the person who got a license, they have to act in letter and spirit. They can't, act against the terms and conditions of assignment. Another one is, I will tell you, in case of registration part. As far as the registration is concerned, is very much important because once you produce the work, where you have to go, how you have to approach, from where you have to get a registration. This is the, the website. Even for registration part, it is elaborately we have to discuss about it. And for the time being, I'm telling that where you have to visit and what all these. But this is the website where they have given the legal provision, they have given you forms, they have given you fee structures for even for literary work, dramatic work, musical work, artistic work, cinematography films, and also sound recording based on the works. For example, literary, dramatic, musical, artistic, 500 rupees. If it is a cinematography films, 5,000 rupees. They have given you forms also to whom you have to approach, because the Delhi there is no office register of copyright. You have to approach. Application form also is there. But if you want to get a right, that you download the form, fill the form, and send it by way of paying the necessary fees. These are all the fee structures. For example, literary, dramatic, musical, artistic, 500 rupees only, but depends upon the work, it will vary. And this is with regard to the registration process. But registration is not mandatory. But once you registered it, as per section 48 of the Copyright Act, that registration will be considered as a prima facie evidence of validity. That means that once you registered it, whenever somebody infringe your work or violate your work, you can go to the court. These are all the cases I would like to share with you. Some dispute in the copyright infringement. I think many of you are aware of it, even the Talavi and other cases. And if you want to take movie from the life history of the particular person, you have to get a permission from the person who is alive, if not from the legal heirs. And one more thing, in case of an infringement of the copyright, there is a punishment. Punishment is minimum 6 months, maximum 3 years. In case of fine also, it can be imposed minimum 50,000 rupees, maximum 2 lakhs rupees. Then you may ask the question, who has a power? There is a court, judicial magistrate court. We can simply call it subordinate court, judicial magistrate, first class court. They have a right. If if anybody violated, you can go and give a complaint to the police station, and they will register the case under section 63. Then finally, what will happen? The trial will be conducted, and there will be a trial in the judicial magistrate first class court if it is city metropolitan magistrate court, and subsequent offences. I think many of you are well aware of it, the pirated version of the movie and multiple copies. It's what is happening actually. Pirated version is always like a dangerous thing. The people used to say that even in the cine industry, in other industries, that pirated copies we get a lot of economically so many issues arise. And what law says, if you came to know that even the new movie next day, it will be copied in a different platform, and they used to take multiple copies. The law is very clear that the law says that as per section 64, not below the rank of sub-inspector of police. In a legal perspective, I'm talking about it, not below the rank of sub-inspector of police alone should re-enter into particular premises and choose the particular materials. Even if it's a CD or computers, they can do that. They can choose it and put it before the judicial magistrate court. And one more remedy is there. If you want to punish the person, you can punish it. At the same time, if you want to get a compensation also, you can get it. For which you have to go to the district court. They're having a jurisdiction to try this vote, and either you can get a compensation, or that means in the name of damages or account of profit. Third one is injunction. If you want to get a damages, for an example, you have a copyright over your work, he exploited commercially, a lot of loss to you, to your to the professions, and the business and all it affected because of the another person. Then you have a right that 1 crore, 2 crores depends upon the commercial exploitation. Another one is account of profit. Whatever the profit he earned it, he has to pay back. But there is an option that either you can claim the damages or account of profit, not both. There is in civil remedies. Normally, what will happen that the people used to prefer the civil criminal remedies, but in case if loss occurred, then they can go for civil remedy because they have every right to do so. And the last one is administrative remedies. As far as the administrative remedies is concerned, if the work is imported from one place to another place, in those days, what happened? That the register of copyright, we have to inform to them, and finally, he will give the permissions that you can do that. But as of now, it's changed. But in case if you feel that your work is violated, you can go to the court, file the case, and get the remedy. But overall, outline of the copyright law, what you have to look into that. First one is what exactly the copyright. You have to go to section 13 and 14 of the Copyright Act. Another one is what right you have it, for which you have to go to section 17 of the Copyright Act. What are right available to you. In case of protection, that means how long you can exploit it, for which you have to go to section 22. If your work is violated or if your right is violated, then you should look into section 51 of the Copyright Act with regard to infringement part. And in case if someone is violating your rights, where you have to go? Police station. And what is the punishment? Section 63, how to look at how long, how many maximum, how many years you will be on jail. But this and all will turn only if you prove the case beyond reasonable doubt. And if someone says that you are violating the right, but you have to exploit their work, if you argue that you use it for academic purposes, there is a provisions under section 52. You have to look into that. Finally, let me to conclude that each and every legislation has been enacted for different purposes. But the purpose for which, if it is enacted, that purpose should serve. But as far as copyright law is concerned, information should reach to all. Why? Because if it is a disseminated, it is like a sound and a healthy one, so that the future generation will be benefited. Thank you so much. Thank you, one and all. Madam.
Participants, post your queries in the chat box, or otherwise unmute your mic and ask directly to the resource person. No questions? So they are very clear. Floraka?
Thank you, ma'am. Thank you so much. Thank you to the participant also for your the patient hearing.
Okay, sir. There is vote of thanks, sir.
Yeah.
Yes,
Okay.
Okay, ma'am. Go ahead.
The best and most beautiful things in this world cannot be seen or even touched. They must be felt with the heart, says Helen Keller. I deem it a great honor and privilege to propose the vote of thanks. First and foremost, praise to the Lord Almighty for making today's event a resounding success. At this juncture, I would like to express my heartfelt gratitude to Dr. P.R.L. Raja Venkatesan for accepting our invitation and enriching our knowledge on copyright. Thank you, sir, for making this is a really fascinating and intellectual section that will broaden our knowledge in the field of copyright.
Thank you, ma'am. Thank you.
We are grateful to our eminent leaders, our Secretary, Reverend Sister Flora Mary, and our beloved Principal, Reverend Dr. Sister A.S. Lucia Rose, our Deputy Principal, Dr. Sister Courtney Teras, our Director of Self-Supporting Courses, Reverend Sister Josephine Jayarani, and our Controller of Examination, Dr. Punita Dharani, for their constant support and encouragement. I want to express my heartfelt gratitude to our HOD, Dr. Glory, for their unwavering commitment to all our endeavors. I like to thank Dr. Sister Aureke Genesis Alphonse, Overall Coordinator, Member Secretary, Deputy Star Scholar Scheme for meticulously planning all events. I would like to thank all the professors for their active participation, who all made this event a successful one. Once again, I thank you one and all.
Thank you. Thank you.
Thank you, sir. Very informative session, sir.
Thank you, ma'am. Thank you,
Thank
ma'am.
you so
Thank you
much.
for your invite, ma'am. Thank you. Thank you, ma'am.
Thank you for accepting
Thank
our
you, ma'am.
invitation, sir. Thank you, sir.
Thank you, ma'am. Thank you.
Dear participants, feedback link is posted in the chat box. Kindly fill it.